the issue of immigration, it still comes to pass that we face a lot of, and the Trump administration is facing a lot of these legal challenges to the deportations. And so I wanted to bring on Will Chamberlain of the Article 3 Project to walk us through quite a bit of this, including a recent motion, or I believe it was a ruling put out by sort of response by James Ho to the Supreme Court that, Will, you were talking about last night. Will, walk us through the merits of the case, walk us through what's happening here, and what was this really just a rebuke to the Supreme Court all about?
Right. So about a month ago, the Supreme Court, in a case relating to the Alien Enemies Act, put out an injunction saying that the government needed to not deport a certain class of people under the Alien Enemies Act. They certified a putative class. This was a really bizarre ruling, and it was really bizarre because no underlying court had yet ruled when the Supreme Court stepped in to issue this injunction. The Supreme Court didn't actually have jurisdiction because it's a court of review. It's not a court of first view. So they need to have some underlying opinion before they actually get to do anything if it's not a case involving one state suing another state over water rights or something like that.
So I'm going to try to make sure I'm translating for the for the listeners here. What you're saying is that the Supreme Court, of course, has the ability to take up cases on appeal and has the ability to make substantive rulings after the process has worked its way up the ladder, so to speak, to the highest court in the land. But this was a case specifically where none of those rulings had yet to occur, and yet the Supreme Court was sort of making the first ruling in an instance where none had been made at a lower court.
Correct. And that's the problem, right? The Supreme Court, this is what's called original jurisdiction. Original jurisdiction is the right to hear a case in the first instance. The Supreme Court doesn't have that. They have appellate jurisdiction, except in a very few number of circumscribed cases where the Constitution actually says cases about this topic or cases between these parties can be heard by the Supreme Court.
Right, the Constitution famously, as you just said, says when it's a state versus another state over, something
Correct.
I'm from Philadelphia, and there's constant fights over, who has to pay for dredging and who has to pay for the harbor and who's going to get the jobs, who is this right or that right, even between the tri-state area, Delaware, New Jersey, and Pennsylvania, or there's also been fights, I think, over Liberty Island. Is Liberty Island New Jersey or New York? It's one of these types of things because it sort of sits equidistant from the various the various states. How was it that New York got Staten Island and not Jersey, for example, and all of these sort of quirks of history. But right, that would be something that would be taken up between the directly at the Supreme Court.
Correct. And so Justice Alito pointed this out in his opinion almost a month ago, where he said, I don't think we have jurisdiction here, guys. And then a week ago, the Supreme Court reaffirmed its injunction and explained itself. And it said in this opinion that, in its view, the district court and the Fifth Circuit Court of Appeals had been slow in how they had responded to the plaintiff's request for an injunction. Meaning the plaintiff said, these guys are going to be deported immediately. You, the courts, must act ASAP. And the Supreme Court agreed that the lower courts were too slow, and therefore had constructively denied the motions. And so therefore the Supreme Court had jurisdiction. And Judge Ho, in today's opinion, I mean, the substance of this opinion doesn't really matter. The Fifth Circuit today, all they did substantively was acknowledge that the Supreme Court had made a ruling and said that the case now needed to be heard again by another Fifth Circuit panel. So there's nothing substantive occurred. But James Ho wrote a concurring opinion where he basically pointed out to the Supreme Court that under their logic, it is now, basically they are now expecting district court judges to be not just having their courts open for documents to be filed 24 hours a day, but rather they need to be following what's happening 24 hours a day. Because the Supreme Court said, well, the district court waited 14 hours and 38 minutes before resolving this case. They started the time at 12 in the morning, at 12:30 in the morning, so just past midnight. So they're basically saying to all these district judges around the country, like, if you don't get to an injunction and rule on it first thing immediately, we can treat it as though you were lazy and didn't bother to hear the case, and we'll hear it anyway. And Judge Ho points out, that's crazy. We're not a Denny's. We're not open for business in the same way 24 hours a day.
So we're not a Denny's.
It's literally in the opinion. He literally says, we are not a Denny's.
And right. And so it's funny that, and this has sort of been I suppose a trend now on both sides, sort of like with liberal justices making references to like Harry Potter and things that we've seen now. And in this, where, this type of language isn't typically included in, legal documents. They're known for being very dry. They're being very, very straightforward. But I think that, you tell me what you think, but to me, it speaks to just the complete aberrant nature of the Supreme Court coming in and essentially picking favorites when it comes to plaintiffs, and by the way, doing so for Tren de Aragua members, right, rather than say, oh, I don't know, a U.S. citizen. A U.S. citizen doesn't get the fast track like this, and that's basically what Judge Ho is saying here.
Exactly. And if you look at the way Supreme Court justices in prior opinions, people like Justice Barrett, have talked about the emergency docket, which is where this is all happening, right? The emergency docket is when you have these emergency injunctions going up to the Supreme Court. All those opinions are about, you need to give the district court time. They need time to make a reasoned decision. We want decisions to be made by the lower court, district court, and the circuit court, so we have the benefit of their consideration and their reasoning. There's all the, you have opinion after opinion like this. And then the moment the defendants are Tren de Aragua terrorists, they're like, oh my God, we need to act immediately.
Right. So. And he's saying this idea that, it is a slapback and it's a rebuke. And honestly, I think that there are certain members of the Supreme Court that probably appreciate his words.
Yeah, certainly Alito and Thomas, who were in dissent here, appreciate his words. And I think also it'll be a wake-up call for Kavanaugh and Justice Gorsuch, who, maybe were, all this stuff is happening so quickly and they're so busy. Maybe they really didn't think hard, which they should have, but they didn't think hard about the consistency of how they approach the emergency docket across cases. And that consistency it's a big part of their legitimacy. If, Justice Roberts and Justice Barrett weren't bending over backwards to let people open their businesses during COVID. They weren't bending over backwards to allow people to
right. There's
go
so many instances of election integrity, others where they would say, "Oh no, we don't want to weigh in. We don't want to weigh in. We want to let the process play out. We want to let the process play out," rather than, but we do weigh in when it's a Tren de Aragua member, and I'm sorry, but when you tie that to Chief Justice Roberts's interview, very rare interview that he gave recently, talking about how it is the role of the judiciary to curb the excesses of the executive, it seems to me like it's very clear they're playing politics. They're just playing politics.
Right, and that's wrong. What Justice Roberts said is wrong. It's the judiciary is not standing above the executive, looking for problems to cure. Their job is to affirm the law and affirm the executive when it is acting in a lawful manner.